Hello, my beautiful people. How you doing today? I'm doing well, thanks. I hope all of you guys are doing well. On this video, we're going to be dealing with a very sensitive issue of disciplinary hearings. A disciplinary hearing. Here yourself, as a worker, you find yourself being charged. Remember, for the company to charge you or for the employer to charge you as an employee, they must issue you a notice. But how many people know what does a proper notice look like? How many of you know what is that must be contained in that notice to make that notice a valid notice? What are the things that you need to look out for when you receive that notice? Right? So in this video, we're going to be dealing with that. Okay, let's jump into it. All right. What to check for in a charge sheet? Right? Notice period. Adequate notice could be as short as 48 hours. The time cannot include a period when you are on leave. Right? Meaning the notice that you are given should not be less than 48 hours. Right? That's a point number one. That's the first thing you need to check on. From the day that you are given a notice, you're told to sign for this notice, and the day of the hearing. How much time are they giving you? Are they giving you adequate time for you to prepare for that hearing? Right. Number two. Then we say, what is unfair? We're still talking about the adequate time that you are provided with to prepare for the notice. Notice that is less than 48 hours. Any notice that is less than 48 hours, it is unfair. What do you do? But then what do you do then? In the scenario where the company is giving you a notice that is less than 48 hours, what do? You ask for adequate time to prepare. And if this is not granted, indicate on record in the hearing that you object. Meaning you don't abscond the hearing. No, you do go to that hearing. Then when you begin to deal with the case, the hearing, then you raise this point, you indicate to this point, and you object to it. So you're not given enough time to prepare for the hearing. Right. Then point number two. Date, time, and venue and name of person should be in the charge sheet. Meaning the date of the case, the time, the venue, and the name should be on that charge sheet. Right. Okay, guys. What is inherently unfair? This should always be clear. Meaning the details that I've just mentioned now, the date, the time, the venue, and the name of the charge person should be clear. If this is not clear, then it is inherently what? It's not inherently fair if these details are not clear. What is unfair? A big gap between the time that the worker is charged and the date of the alleged offense. Right? Whereby the employer takes 3 months or a month, 2 months, then they charge you afterward. So when you're getting a notice now about an incident that took place when? 3 months back. That's unfair. Then what do? You check what the collective agreement says. In those industries or sectors where they do have the collective agreement, you check what does it say on this matter. If not satisfied, object on record in the hearing. Again, you don't abscond the hearing. You go to the hearing, then you raise it in the hearing. Right. Then let's go to point number 3, the charges. What is inherently fair? Charges should be very clear. They should include date and place that offense took place. Whatever is it that you are charged with should be very clear. Should be clear what is it that you are charged with. When did it take place and where did it take place? What is unfair? If charge is ambiguous and unclear, if the charge against the member does not fit the incidents described. Right? Okay. Then what do you do about that? Ask for clarity of charge. Ask them to clarify, give you more details about what is that they're charging you about. So able to prepare an adequate response or defense. The rights in the notice. Accused workers have the right to call witnesses, lead evidence, cross-examine company witnesses, be represented by a shop steward or an employee of your own choice, as well as have an interpreter. These details should be written down in the notice. That disciplinary hearing notice you receive must state these rights to you. Must state these rights. Right. What is unfair? Not being afforded an opportunity to exercise any of the rights. Right. Then what do? Check what the disciplinary code says and object on record. Right? You must raise it in the disciplinary hearing. That these rights were not explained to you. The notice did not contain these rights. If your notice didn't contain these rights, right? And again, guys, it's very important. Let's familiarize ourselves with the company's code of conduct. That's very key. Please ask for it. So you familiarize yourself with it. It's your right. You must have it. You must know what is contained there. So you don't find yourself caught off guard with these things. Guys, please share the video. Please like and subscribe to the channel. For now, we leave it there. Siyabonga. Gamako. Makhanye. Lesedi.